I think we're going to have a small group today, so I'll go ahead and get started. So we get this done, and whoever needs to eat can eat. I just wanted to remind all of you that there's a new administrative order regarding adversary procedures, or procedures in adversary proceedings. I just asked Brian Zinn to post that to our website. If you didn't get the email from the court. But that one hit the books on February 1st of 2015. It's Administrative Order FLMB 2014-10. Probably find it on the court's website as well. And then there's another administrative order, 2014-6, which supplements the local rule 970-1 to provide for exhibits in electronically stored format at adversaries and FEHs. Also, another thing I want to let you guys know, I spoke to the gentleman yesterday. The judges are getting together, I think, next week in conjunction with the Pasquet, I guess it's not next week.
It's 2 weeks.
In 2 weeks, in conjunction with the Pasquet seminar. And she said that she's going to bring up an issue that was brought up here when she came to visit us for the State of the District address. And that issue is whether we can send the actual motion with the notice of hearing rather than serving the motion and then later serving the notice of hearing on that same motion. We won't be able to self-calendar, but she's thinking that that's probably a good idea to do that to cut down on mailing expense. So hopefully all the judges will be on board, and then we'll be able to, file a motion, get our hearing date, and then serve it all in one packet so we don't have to do multiple mailings. So she'll let me know how that turns out. Also, if anyone hasn't signed up for the Pasquet seminar, I think, is today the deadline to save the $50, Luis? Or
I don't remember, but I was going to suggest that.
Yeah, but go ahead and sign up. We circulated I circulated an email from the ABI that has the discount code.
All the hotels are full.
Yeah, the hotel's full, so you're going to have to find somewhere else to stay. But I think even with the discount, the hotel's pretty expensive. But the discount code at checkout when you sign up on the ABA website is all caps Pasquet 50. So just so you know. Another thing I wanted to bring up to your attention, I sent an email to the membership about the passing of Joey Schlossberg. I don't know how many of you knew him. He practiced in St. Pete and Tampa area. Super great guy. Terrible tragedy what happened to him. It's very unfortunate, but they have set up a fund for his children's education and also a fund to help his wife with the day-to-day expenses until the insurance company pays off on his life insurance policy. And I spoke with Jerry McHale. He suggested that the association make a $500 donation to Joey's family. And I said it was fine. I just kind of approved it without bringing it to the membership. But I just wanted to let you know, if anyone has an objection, please let me know. But we're intending to make a donation to that fund for Joey's children. And that's all I have as far as current events and news. Now I'm going to bring Greg Champeau up here. He's going to give us a little brief summary of the recent Chapter 13 seminar that the Tampa Bay Bankruptcy Bar Association held. What, 2 weeks ago?
2 weeks ago, yeah, 2 weeks ago tomorrow. It was actually it was well attended. We were a little bit concerned because the attendance was not so good. I think we got a big draw at the gate that day. But it was more of a practice pointers, best practices kind of seminar. I'll pull out some of the highlights of it. It went long. It was only scheduled for a half a day, and we could have talked the full day on everything that we needed to. But a few things that I think the trustees pointed out that they want to kind of emphasize and pass along to us as practitioners. The first of which is be aware of the new forms that are out there. If for some reason your software hasn't updated them yet, make sure you get the new forms in your database, start using them, use them, and know what's in them. Because there are a lot of provisions now, particularly in the new B22, C1, and C2, that might be beneficial for your clients as part of your practice. I'll just point out a couple of changes that you might want to take a look at. Some of these changes, I'm sure, are going to engender some type of litigation and opposition from the Chapter 13 trustee's office. But if you look at the first provision that falls under B22C1, now we have actually two forms of B22, C1 and C2. Number 13 speaks about the amount of deductions you can take for the spousal deduction if you're not filing a joint case with your spouse. And it gives you a little bit more direction as towards the types of things that you can deduct and not have included in the median household income. It gives you a kind of a non-exhaustive list of spouse's tax liability, spouse's support, or support of dependents. So, Larry?
Did they say when this takes effect? Or is this
I think it's already implemented, Larry. I think we should have been filing this as of, I believe, either the end of January or the beginning of February.
this year?
This year, yeah. So this is up and running stuff that we.
Only applies to cases filed after?
I believe so. I can confirm that, but that's my understanding. The income section is largely the same as it was before. It has the same types of things. We calculate income the same way. It has a little bit of a different method of calculating self-employment income, so just make sure you get your profit and loss statements. The trustees pointed out, try to get as specific as you can with your profit and loss statements. If you have a non-savvy debtor who doesn't keep the best books and records, just having income and a bulk of monthly expenses doesn't really help the trustees from their perspective. If you could give them some kind of a breakdown, this is what I pay for, vendors, this is what I pay for rent, this is what I pay for insurances and what have you, that's a much better way, and it's more comprehensive, and it makes the trustees' job and function a lot easier as part of going through an analysis of the B22C. The next change that I think is of some importance and may impact you deals with the second part of the B22C now, and that's C2, and that's the expenses portion. And the first one that kind of jumps out at you, because this was the subject of a fair amount of debate previously, is the determination of the number of people in the household. Paragraph 5 now, and I'm reading verbatim from the form, fill in the number of people who could be claimed as exemptions on your federal income tax return, plus the number of any additional dependents whom you support. This number may be different from the number of people in your household. So that's a fairly drastic change from what we were listing before. Like I said, the trustees are probably going to vet this issue pretty seriously. Yes,
I have
Jeff?
a suggestion. We got president, we got 535 representatives.
Throw them all in there, Jeff. You'll never have a means test problem again. But it's really something to think about, because I know we struggled before. How do we determine the size of the household? Do we go by a heads on beds type of analysis? Do we go by how many dependents are listed in the tax return? Now this seems to say you can basically throw in anybody who you might be able to claim as a dependent in your household. So that's something you might probably want to take some time and go over and take a look at. The second kind of catch-all provision that comes up on number 10 is that now we have a catch-all where if the numbers don't equate out, if you think that the numbers that the IRS allowances are providing you are insufficient, you have a line item where you can kind of explain what's going on. Before, you just kind of checked a box, and that engendered a lot of back and forth with the trustee's office. Under number 10, at least you've got some space there where you can explain a little bit of what's going on. Another one that you probably want to make note of is number 14, and that's the public transportation expense. And basically, they've changed this to read that if you claimed 0 vehicles in line 11 using the IRS local standards, fill in the public transportation expense allowance regardless of whether you use public transportation. So if you are not able to claim any type of vehicle allowance, maybe because they're free and clear vehicles, or you know, they're borrowing a vehicle from a relative or a friend, according to the wording of number 14, you'd be able to claim at least a public transportation allowance. Taxes is another change that you probably want to pay attention to on line 16. And what I'll do is I'll mark up a form and I'll get it to Paul so we can blast email it. I didn't have the opportunity to go through and print out one for everyone today. I was kind of working on a little bit of short notice. But the taxes provision is something you want to go through and kind of make sure you have accurately reflected when you go through the analysis. And that says that the total amount that you actually pay for federal, state, and local taxes, which is similar to what it was before, such as income taxes, self-employment taxes, Social Security taxes, and Medicare taxes. You may include the monthly amount withheld from your pay for these taxes. However, if you expect to receive a refund, you must divide the expected refund by 12 and subtract the number from the total monthly amount that is withheld to pay for taxes. Now, that doesn't make a whole lot of sense the way that the trustees in virtually every case now require us to submit tax returns and refunds to fund the plan. So that might be the subject of a little bit of at least change in this division, but it's something you just want to be aware of in the form. Education, number 20, you can deduct out you can deduct out the amount that you pay as a condition of your job. That was something else that wasn't present before. And there's also an allowance for insurance, not that you've historically paid in the past, but that you anticipate to pay in the future now. So there's several different changes to the B-22C forms, largely on the expenses side, but it's really worth going through at least once in some kind of fine detail so you got a good handle of what's going on, what you can expense out, and what you might run up against some opposition with from the trustee. Otherwise, from the seminar, it was largely the same types of issues that we all kind of come across. The trustees emphasized that the sooner that you can get working on your files, the better. The sooner you can get your motions filed, be that lien strips or lien avoidance motions or motions to determine secured status or to value vehicles, the earlier you can get those done in the process is always the better, because you won't have to go through multiple confirmation hearings, you know, continuing these over and over. They also said and kind of emphasized that you want to spend time going through the claims register. And it doesn't hurt to actually go through the individual claims, because at some occasions the claims on the claims register don't actually reflect what are in the claims. You'll also want to make sure whether there's any type of provision that's in the claim for a reservation of rights. So you might have an issue of a bifurcated claim at some point down along the road. They also pointed out a new provision, at least from Fort Myers, but they're doing it up in Tampa, is instead of putting a dollar value to the unsecured creditors, their dividend in the plan, in Tampa they've been simply listing it as pro rata. And the trustees were okay with that idea. That way, if something happens in your plan, if there's a change in the monthly payment, you don't have to go back and readjust and, you know, recalculate the amount that you've got to pay to the unsecured creditors. So that's something that Kelly Petrie had brought up that they do in Tampa fairly regularly. John, Mr. Waggy, had said that he doesn't have any opposition to that. So you can take that for what it is. If you want to start using it, I think it would probably be accepted. We talked a little bit about modification of plans, when you want to do this, and the things that you should have. A lot of it is commonsensical. I mean, if there's been a reduction in a budget, if there's been a loss of pay, just make sure when you file your motion for modification, you provide, you know, supporting financials. You send a new Schedule I and J with supporting pay stubs. The trustees, as we all know, are requesting annual tax returns and refunds, so we may be seeing motions to modify on a more regular basis from their office. They talked a little bit about early payoffs, and we all basically know that Judge Delano disfavors early payoffs. From a practice kind of standpoint, you know, if you've got a small amount of creditors in your case and your debtor wants out of your Chapter 13 case as soon as possible, go to the debtors, go to the creditors and talk to them about it. I've had a fair amount of success, saying, well, the debtor has the availability to leverage some money from either an exempt account or from a family member or friend, non-debtor funds, and he can tender payment to you now or at the end of the plan. And there are many occasions where the creditor will go ahead and agree to withdraw their claim and enter into a settlement. I find it a good practice to file a motion to compromise so that everybody's noticed and the court's aware of it. But that's a way to get around this general aversion that we've had to early payoffs. Open up a discourse with the creditors. That's the one thing I think that we don't do enough of in Chapter 13 that we do more of in other types of bankruptcies, 7 and 11s. And if you have this dialogue and if you have this discourse, you might be able to diffuse a lot of the issues that are obstacles to confirmation, modification, or early payoff. Last things that really weren't discussed formally, but were kind of bantered around, were student loans. I've seen a lot of action lately for administrative garnishments on student loans. Folks just don't have the ability to pay, and we've been filing on a fairly regular basis. Chapter 13 is designed for the sole and exclusive purpose of basically keeping the student loan creditors at bay for 5 years, waiting to see if they qualify for any of the government forgiveness programs or maybe internal forgiveness programs. And it's always good to reach out to the lenders and find out what type of loss mitigation alternatives they have. And then sometime within the 5 years, maybe Congress will take up the issue because Lord knows it needs to be vetted. Those were kind of the high points of what were talked about there. Thinking about doing a similar type of seminar down here. I encourage it. I think it would be great for everybody down here to kind of have the trustees there as a sounding board and have a open dialogue as far as a bunch of the issues that are of concern to them and of concern to us. But that's basically what they talked about.
Thanks, Greg.
No problem.
Luis, did you want to give a case law update? Yeah. Luis is going to give us a little case law update on something he's been following. I think we've all kind of been following. And then I think that will probably be it after Luis is done. And then I just want to give you guys a very advanced warning. We have Larry Hinkle signed up to give a seminar on May 21st. So it's a couple months away. He's going to be speaking about the dischargeability of tax debts. He puts on this full-day seminar, and he is compressing it for us to have at our luncheon. So I just
One of
wanted
the best speakers you're ever going to have.
Yeah, I heard it's wonderful. So jot that down, put a little note.
What was
mark
that date
calendar.
again?
May 21st. And then the next meeting will be when Judge Delano is here on a Thursday. I'll blast out a date. I'm working on another seminar speaker for, we may not be able to get him next month, but definitely the month after, hopefully. Please, thanks.
All right, I just wanted to give everybody a couple updates. Or one, an update on what's going on at the Supreme Court with McNeil. Certainly it's of interest to me, and I think it's of interest to the Chapter 7 practitioners. But before I do that, I wanted to encourage everyone again to, if you can, to sign up for and attend the Pasquet seminar. Judges Delano and May have made a point to invite and involve Fort Myers practitioners in the seminar, and Judge Gentleman has made an emphasis, to involve practitioners down here in the affairs of the district as a whole. And so I think that if you can, you should try to register and attend and sort of support them in turn. The deadline for that coupon code, that $50 discount, is today, so you'd have to register by the end of the day. And the code again is capital P Pasquet 50. So McNeil, the briefs are in, or at least they should be in. The appellant's brief was filed late January, early February, and is available online. You can get it at SCOTUS blog. The arguments for sort of overruling McNeil are not surprising. Obviously that the Supreme Court's construction of the language in 506A in the Dusnip case controls that in enacting the code, Congress did not intend to abrogate the pre-code position or law that liens pass through bankruptcy unaffected. So that's sort of the crux of the argument. The supporting arguments are one, that Congress has since Dusnip twice amended the code, including amending 506 in BAP CPA, and that they chose not to overrule or otherwise affect the Dusnip interpretation of 506. And so the appellants, the Bank of America, cites to some cases for the proposition that you sort of implicitly reaffirm the holding of a Supreme Court where it involves statutory construction, or the legislature does, Congress does, by not overruling it. So silence is consent to the Supreme Court's interpretation. The appellees' briefs were due on the 17th, so the day before yesterday. They are not yet available online, and I actually checked the docket this morning. It doesn't even reflect that they were filed, but I've got to assume that they were filed, and I suspect that they will argue for an abrogation of the holding in Dusnip, but maybe we'll talk about those when they're filed. And so that's where we are. Oral argument is scheduled for March 24th, so a little bit, 6 weeks from now. And I would expect a decision at the end of the term, I think, unless, they think, unless it comes sooner, the proposition overruling McNeil, I think, if they think that the 11th Circuit was so wrong, it might come sooner, but I would think, July decision. So there's that. So if your practice involves the representation of debtors, then you better get lien stripping, because it may come to an end if you represent creditors like I do. I've been taking appeals of them, both the district court. Well, we'll find out. I have a few that are at the 11th Circuit, but the district courts, the judges are receptive to motions to stay pending the Supreme Court's ruling, and obviously that's the most efficient way to deal with those. Any questions on that? No. Larry, do you have any pending? Are you following it?
I have one that's pending, but I'm never going to pursue it. For those of you who don't know, there was a case by Judge Gentleman a few years ago called the Hoffman case. And in Hoffman, I actually relied upon a McNeil-type decision the other way. And there was five debtor lawyers and a lawyer that was on behalf of NACBA.
National Association of Consumer Bankruptcy Attorneys.
Right, and so Judge Gentleman, we had an all-afternoon hearing. Oral argument went on for hours, and she ultimately wrote a decision, which I think is the best one I've read so far on the issue. And then it went to the district court, got affirmed, but then at the same time this was going on, apparently McNeil was going up a different food channel, or a different means of getting to the 11th Circuit. It got there, and the Supreme Court's decision, as you probably know, in Dusnip had a very unusual, or it's almost tortured reading of 506D. And so when they got to McNeil, they said that, well, you hadn't really overruled precisely on the issue of lien stripping. You had only dealt with lien strip downs. And so we're going to still follow our decision in a case called Follendor. So, is this being taped, by the way?
It is.
Well, then I'm not going to tell you the joke. If you shut the tape off for a minute, I'll tell you. Shut it off. actually, I don't think there's any way intellectually to square McNeil with Dusno. You have to get to the same point. You have to use 506. And the Supreme Court says you can't use 506 because 506 has to have a catalyst, some kind of additional statute. And what they've seized on in 13 is 1322B as a catalyst, but there's no similar catalyst in Chapter 7. So I predict that if you had a similar makeup of the Supreme Court, they would slam it immediately. It wouldn't even have oral argument probably. But because you have a completely different dynamic now for the Supreme Court, and if you want to read an interesting dissent, read Justice Scalia's dissent in Dusno, because he slams the majority. Says that you don't know what you're talking about. And so, end of the day, you could have with this different dynamic, you could have a different decision. So it's going to be interesting to watch.
Yeah, I suspect that we'll be waiting until July to find out. I think there'll be a lot of discussion. Again, if you can attend the Pasquet seminar, please do. I'm speaking on the Consumer Case Law Update panel. Matt Holtzinger is always also a panelist, not on that panel.
And my panel deals with claim-related issues, so talking about the 11th Circuit Crawford decision, which deals with like claims barred by the statute of limitation and FDCPA violations. Talking about escrow and claims, some other claims-related issues like that are a lot of it's relevant to creditors' attorneys. There's some cases that are sort of forewarning to creditors' attorneys who are signing claims on behalf of creditors. There's some pitfalls there, so we're talking about that kind of stuff. I think Kelly Remnick's on the panel, trustee, and she's talking about the late file claims issues. So that's what our panel is about.
Well, our consumer law update panel, it's myself, Judge Mary Grace Deal from Atlanta, and Chip Herron from Orlando. And we're going to talk about issues that are absolutely would be of interest to you, that are pertinent. Judge Deal's going to talk about dismissal and conversion issues in Chapter 13. There's some interesting cases that have come out in the last year. She's also going to deal with the lien stripping McNeil situation. She was one of the first judges to publish an opinion that, of course, followed McNeil but criticized it as being irreconcilable with DUSNIP. We're also going to talk a little bit about Law v. Siegel and jurisdiction by consent. And then the two topics that I've been assigned are, ones I had not been following, but I think are interesting. The first is the 11th Circuit's decision almost a year ago in Ray Brown, Santander, which determined that for purposes of surrender in a Chapter 7 or 13 case, I guess mostly in Chapter 13, secured creditors are required to utilize the replacement value. So that's going to cut down a lot of deficiency claims and the potential for deficiency claims, because instead of being able to use the old Article 9 standard or the state law UCC standard, where it's your forced sale plus less cost of sale, you just look at replacement value, and so you can be looking at clean retail, I guess, or the actual condition, but.
Funny how the creditor and the debtor positions totally go 180.
Yeah.
All of a sudden, the creditors argue in favor of a high value, and the debtors argue in favor. So you should each hire each other's appraisers.
Yeah. So you're going to get a switch there. You're going to want to use the appraiser that I usually hire on my car valuations. And then another topic is forced surrender of collateral in Chapter 13 cases. And I wasn't aware of this, and only encountered it in the Chapter 11 context, but there's some interesting cases that have come out in the last year that address this point. And factually, it seems to be cases where the debtor is surrendering a homestead, a real property, a condominium that's subject to assessments, or another home that has a homeowners association, where you have the problem where the creditor perhaps sought relief from stay but won't foreclose or won't complete its foreclosure, and throughout the pendency of the Chapter 13 case, you're accruing liability, post-petition liability for assessments. And so what do you do, Larry?
The flip side of that issue you might want to talk about in your presentation also is that what does surrender mean in Chapter 13? Because we're seeing a lot in the foreclosure, you may be too, the plumber kind of case that talks about if you put surrender in your plan, that you cannot defend it in your foreclosure action.
That's why they changed the model plan to put that extra provision in the model plan. But I'll talk to you about the ongoing assessments being dischargeable in 13.
Well,
Because there's a specific exclusion for that in 13.
Well,
Yeah,
these
1328A versus B discharge.
Yeah.
Well, these cases talk about, the difference between surrender and vesting in the code, and the fact that, is it 1322 provides that the plan may provide for the vesting of property of the estate in the debtor or in any other person. And so you seem to have, at this point, sort of three cases, and there's an interesting one, In re Watt. It's at 520 BR 834. It's the bankruptcy court for the District of Oregon, 520 BR 834. But it sort of talks about the two, or sort of two arguments, an argument for and an argument against, and then this judge sort of goes another route and says a third argument for. The for case, or the one that she discusses in the most recent one, is In re Rosa. It's 495 BR 522. It's the District of Hawaii, 2013. In that case, the court talked about the difference between surrender and vesting and said that surrender is not vesting, and under the provisions of 1325 that require the three options, surrender being the third, that you can't vest, that you can't force. Surrender doesn't force the creditor to accept the collateral. And in that case, though, she says, well, there was no objection, and so the failure of the creditor to object to an express provision that said that the surrender is you have to take it, that although the code generally wouldn't allow it, that the creditor had accepted the treatment by not objecting.
And haven't some lawyers had their clients quit claim deed the
Uh-huh.
property to the secured lender?
And I think that that's what happens here. Generally, under Florida law, you have to have acceptance.
Yeah.
And the other case I was going to cite to you is the North Carolina case, but it deals with Florida law, and it talks about you need to have acceptance. And so you can't, in the Chapter 13 contest, force the creditor to accept that. And that's the Rose case. You have Rosa says yes, Rose says no. Rose is at, I lost it here. Rose is at 512 BR 790. It's the Western District of North Carolina.
By creditor, do you mean the HOA or do you mean
No, the bank.
Is there a way to fix the HOA section?
Well, I hadn't thought of that. I would think that the analysis is much the same. And though the analysis might be, the HOA might be more inclined to accept the conveyance because then, they can relet it and, they can lease it and sort of mitigate their damages, whereas.
The other one is getting, by the 1% thing or whatever.
Well, and that's a good point, and that's one of the points that's addressed in the Watt case in Oregon. The bankruptcy judge says, it's not so much the debtor that's suffering, but it's everyone that lives in that HOA or condo association, whatever it is, because the assessments are going to be capped at the 1% or whatever they are under the Oregon statute, and so the judge was inclined to allow it. There, she said there was a distinction between surrender and vesting. This judge says she disagrees with both the Rose and the Rose cases, courts, and says that you can't, under 1325, force 1325 surrender. You can't force them to accept it, but the plan may otherwise provide at confirmation that the property would vest in the creditor.
What are those sites again, please?
The Watt case is at 520 BR 834. And that's Western District of North Carolina. Excuse me, that's the District of Oregon. October 15th, it's brand new. And then there's the Rosa case. That case is reported at 495 BR 522. It's bankruptcy court for the District of Hawaii. It's a 2013 case. And the last case, these are not all of the cases, but the ones I'm planning on talking about. The Rose case is at 512 BR 790. Bankruptcy, Western District of North Carolina.
What if you have multiple secured creditors that you surrender to, first, second, third mortgages?
I guess you pick.
I mean, if you surrender all, I mean, basically to one title.
I mean,
You're surrendering to all three.
I think that the takeaway maybe from a practitioner's perspective, or from the debtor's perspective, is that there's some leeway for creativity. And, at least some judges are going to be willing to consider these creative arguments. I don't know of any Florida decisions. There's a case that I pulled from Westlaw just this morning while I was listening to Larry and Richard go at it upstairs. But Judge Specie has a case. It's an order on an adversary proceeding. It doesn't appear to be published, but it, in a very lengthy footnote, addresses this issue. And that's all I noticed so far. You'll have to go to the seminar and find out my take on Judge Specie's take. But I think it's important for us to support Judges Delano and May. I mean, they certainly support us and made great effort. So if your practice allows it, you should try to attend. And we really do have some worthwhile presentations. It's not as Chapter 11 focused as it was 5 or 10 years ago. They have dual tracks, a business track and a consumer track. The consumer program is primarily put on by practitioners and judges, and the topics are ones that I think would help you in your practice. So sign up today. PASCAE 50 is the coupon code. You save $50. It's like 10 or 15%.
And I'm going to be on a panel as well. The plenary session is Saturday morning, so it's probably going to be super heavily attended. Because Friday night, I think they have that bar crawl or dinner crawl or whatever. But we're going to be talking about electronic discovery, social media, and then also ethical considerations in asset protection planning and counseling. So if anybody here has any war stories that they want to email me about issues they've had with clients and the advice that you give them when you're doing some asset protection counseling, and without naming names, like things that have gone south in your practice, share them with me, because that's the kind of stuff that other lawyers want to hear about, is cautionary tales of how of what to watch out for when you're engaging in that type of practice. So.
There's also going to be a very good panel. I think it's Thursday afternoon. It's sort of like a view from the bench on bankruptcy appeals. I haven't had too many, but I've got 4 or 5, 6 or 7 pending at the moment, and you don't get oral argument at the district court, so or at least I haven't in any of my cases. So it's interesting to hear the judge's take on what works and what doesn't, what's compelling, and just their take on it. Judge Steele, I think, will be one of the panelists, so you'll get a Fort Myers take. You've got a 50-50 shot of getting Judge Steele, so I'm interested to hear his views.
Yeah, so it's going to be a good program. Yes, Mr. Cecil.
Hey, have you guys heard or talked about the proposed bill in Congress to discharge student loans?
Greg briefly touched on it, but not really.
Okay, Congress.
Yeah, I
I'm
don't-
really busy really quick. That passes.
It'd be great, but I don't see it happening, Mike.
I think you were there, Mike, but for those that weren't, and maybe Larry was too, at the bench bar conference, we probably spent a third or half of it talking about the student loans and how big of a problem it is, and how you can address it. Unfortunately, the best minds in the Middle District couldn't come up with a solution.
I mean, the hardship
Maybe
issues are.
Yeah.
I think the one case that they that was an example of someone where actually they got the discharge was they were permanently disabled and just, couldn't work.
Not permanently disabled necessarily from a social security perspective,
No.
but from like a common.
Yeah.
A
You
real
know.
one.
Yeah, like,
Well, like completely
Like-
disfigured.
yeah, like in a wheelchair, brain damage, just, missing limbs.
And the real problem was that Bruner was decided back when you could still discharge after 7 years. That's the problem.
Larry?
Judge May wrote a decision, I think he wrote it, he had a case in which the guy was such a horrible person with people, had no people skills, that nobody would ever consider employing him.
I think they paraded in his old bosses and put him on the stand.
So this guy is such a complete ass that we would never hire him in a million years. He's not employable.
He got Judge Williamson to recuse himself in the middle of the day, I think is what happened.
And I think Judge May discharged for that.
They did. I don't know the case.
Probably didn't want to deal with them anymore.
Well, but
So there's hardship and then there's an asshole. Discharge, nice. We'll edit that out. Thank you very much, everybody. We'll see you next month.